Welcome everybody to The Break. This is PIA's video series, hopefully tackling a complex issue of insurance and distilling it down to a few minutes for all of you. Today we're going to be covering the topic of workers' comp and COVID-19. We have talked about this in the past, but today we are going to talk about in particular the recent rash of executive orders and legislation creating a presumption for certain employees that if they contract COVID, that they've contracted it at work. And Clare is going to dive into that in more detail. Quickly, I'm Brad Lachut. I am the Director of Government Affairs for PI Northeast. And this is Clare Irvine, who is our resident expert on this particular topic. And I will turn it over to her so that you guys can learn a little bit more about this COVID workers' comp legislation and the executive orders that has happened in the Northeast. So Clare, take it away.
Great, thanks, Brad. And as Brad said, we did a more deep dive on workers' compensation and potential coverage under the status quo for COVID. Just for a refresher for those who might still be on vacation mode since it's August, at least when we're recording this, is workers' compensation is a type of insurance that just covers injuries and illnesses contracted through the course of employment. And it's highly regulated by a state agency. So for physical injuries, it's fairly easy to prove. You slipped in your office kitchen, you got hit with something that fell from the ceiling, you got physically injured in your office, covered. More difficult is the issue of illnesses. So ordinarily, workers' compensation coverage excludes kind of common cold, flu type illnesses that you risk contracting just in ordinary course of being around other people. That was something we once did and we'll hopefully do sometime in the future. It does though provide some coverage for workers if there's an increased risk of contracting said illness. So in order to get workers' compensation coverage in those situations, the employee has a duty to prove either that their particular occupation led to an increase of likelihood of contracting the illness, or that the risk of contracting the illness was in excess of ordinary hazards of employment. Those are lawyer terms to effectively mean in the ordinary office, if one coworker shows up, gets the flu, and suddenly everyone else starts getting it, there's nothing about the office conditions that led to an increase of that. However, if you're an emergency room nurse and it's December and you contract a viral illness because you're in close proximity with a lot of people with the illness, you have a stronger case for claiming workers' compensation coverage under the ordinary workers' compensation law. However, COVID, as you probably know, has changed everything because it's both very highly contagious and spreads before people realize they're sick. And as a result of these circumstances, states have been temporarily changing their coverage for COVID-19 so that employees don't actually have to prove one of those two things that they are at an increased risk of contracting COVID in the course of their employment. Instead, it'll just be presumed that these workers contracted COVID in the course of their employment. So it doesn't drastically change workers' compensation law, but it does kind of make it easier for employees to claim. There are limitations for which employees and the time frame for the change. And while it does allow these workers to claim workers' compensation coverage if they contracted COVID and assumes they contracted COVID in the workplace, the employers and or their insurers can still seek to prove that the workers contracted COVID in another way. So if you saw on Instagram an employee was at a giant pool party and they contract COVID, but they were also, and your office has been taking every PPE recommendation, all the social distancing and everything, you can use the pictures from Instagram as an argument against this if all the other circumstances were to apply. Odds are the specific circumstances would still not apply to that worker, but employers and their insurers, again, can prove otherwise. So the presumption doesn't mean it's automatic coverage, it just shifts the burden of proof from the employee to the employer and their insurer. So just as the quick rundown, for Connecticut, it was Executive Order number 7JJJ. It created a rebuttable presumption that workers who contracted COVID-19 between March 10th and May 20th, 2020 are eligible for the for the workers' compensation coverage. The requirement is that those workers must have worked at least one day of the 14 days preceding the contracting COVID outside their home. So a stay-at-home, someone who was working remotely during that period who contracted COVID probably didn't get in the office because they weren't in the office. And that's also pretty much, that same logic applies to all the other states as well. In New Jersey, it was passed through Senate legislation and signed into law by the governor. It's similar rebuttable presumption that essential employees as defined in the legislation and other emergency legislation contracted COVID-19 through the course of their employment for the duration of the public health emergency. So it's a longer period of time than Connecticut, but a narrower definition of workers, or at least within the legislation or executive order. It does also exclude employees working remotely outside the workplace. New Hampshire, same thing. But they use the definition of emergency response and public safety worker as defined in the current workers' compensation law, RSA 281-A2VC. It's very, kept on memorizing that one. And it lasts for the duration of the state of emergency. And the state of emergency keeps getting extended. So it's still technically going on, even though it was started in March. Vermont actually creates two categories. It's a presumption for frontline workers who test positive for COVID-19, but for non-frontline workers, they must document that they had a positive COVID-19 test and exposure in the workplace. So it'll be interesting to see how some of that turns out, particularly when you have people like grocery store workers who might be claiming coverage, and it's easier for them to claim under the other states. It might be a little more difficult for Vermont, but we'll see what happens. And that was Act 150 or Senate Bill 342. And if you're wondering, if you're a New Yorker and wondering where New York is, they had introduced legislation in this state assembly and Senate. It hasn't passed or gotten close to passing yet, but if that changes, PIA will send out an update. Meanwhile, the status quo from pre-COVID would apply. And the Workers' Compensation Board has posted information about employees who are seeking workers' compensation coverage for potentially contracting COVID in the workplace. That's linked to below in place of a bill, legislation, or executive order. And so if all states are slightly different, but kind of the same overall concept of certain employees who were working, particularly during the peak of the crisis, it's presumed that they got COVID in the course of their they probably got in the course of their employment and are eligible for workers' compensation coverage. And with that, I will just put up our contact information. If you have further questions, contact Brad, myself, or the PI Resource Center. We'll continue posting updates on this and other issues, such as if New York passes legislation regarding this issue, if you believe that an employee may be eligible under at least the time frame and going into work criteria, just double check the definition for employees within your state. They're all slightly different, and that can make or break their claim. And even if they're excluded under that, they can still make a claim under the previous burden, where they at least have to build the argument as opposed to presuming to have gotten COVID that way. So Brad, do you have any further questions or points to add?
No questions. You did a great job. Just one point of clarification. The New Jersey legislation has not yet been signed by the governor. It's been on his desk for about a month, which is a little surprising. All indications are that the governor will sign it. It just hasn't happened yet as the time of recording. But I expect that it will happen in the next couple days, I assume.
Yes, so if you're submitting a claim in New Jersey, wait till we post information about it being signed.
Exactly, there you go.
So, okay, well, thanks everyone, and I'll have another video soon.
Thank you, everybody.